Got it. Good evening and welcome to the candidate forum for the Los Angeles County Superior Court, office number 124, presented by the League of Women Voters of Los Angeles County. I am Margot Reed, the president of the League of Women Voters of Los Angeles County, which is composed of 10 local leagues throughout the county. We are a nonpartisan grassroots organization working to protect and expand voting rights and ensure everyone is represented in our democracy. We empower voters and defend democracy through advocacy, education, and litigation at the county, state, and national levels. We put on candidates forums as part of our voter service activity so that voters can listen to the people vying to represent them in county government. Los Angeles Superior Court judges are elected locally or appointed by the governor to 6-year terms. In order for a person to run for judge, a lawyer must be a member of the State Bar of California and have been in practice for at least 10 years. Leading up to the March primary, the League of Women Voters is conducting forums with all 9 contested judicial seats, and these forums will be posted on YouTube at LWV LAC. The moderator of this forum this evening is Fatima Malik, who is a past president of the LA County League, a former communications director for the State League of Women Voters, and an experienced forum moderator. The candidates this evening have agreed to the League's rules, which require that they speak only about themselves and adhere to our time limits. We thank both of our candidates this evening for seat number 124, Kimberly Rebecca and Emily Teresa Spear. And now I will turn over our event to our moderator, Fatima Malik.
Thank you, Margot. Okay, well, let's start with opening statements. We'll go in alphabetical order, so we will start with Kimberly Rebecca, whenever you're ready.
Thank you. I'm running because I am a career public servant. Most of my experience has been in dependency court and in criminal court, but I've also volunteered with, trained and studied housing issues, public benefits, family law, immigration, licensing, small claims, and employment law. I just never wanted to tell someone, sorry, I don't know how to help. So I've tried to educate myself so that I felt like I could always help. And I think that that's made me a very good public interest attorney. And I think it makes me in a very good position to be a judge in just about any setting that they place me. I've represented victims directly, not as my witnesses, but as my clients, including children and adult domestic violence victims. And I've also represented criminal defendants, many of whom have trauma histories of their own. Because of that, I have a very holistic view of cases, and I tend to think about how to actually try to resolve the issue to everyone's satisfaction and to look at what the issues are for each individual and try to resolve those to the best possible result to bring about a just result.
Thank you. And next will be Emily Spear, and you have 1 minute.
Thank you. I am in actuality a judge, and I have worked in just about all of the spheres that were just referenced, which is to say that I have presided over trials in civil small claims, civil appeals. I have also presided over criminal trials, both felony and misdemeanors. I have presided over restraining orders and over family trials, and I am committed to women and children, so it's kind of a near and dear thing to my heart. I worked in it's always hard to talk about sexual violence, violence against children, and domestic violence, and so I have advocated for those persons in my actual advocacy as a district attorney, but also in family, where it all kind of coincides. It's another it's a similar issue in a different venue. And so I think that I am the best person.
Thank you. Okay, let's get started with questions. You'll find that most of these questions have two parts to it. So if you need me to repeat a question, just let me know. Since Kimberly started first, we'll start with Emily this time. In our criminal justice system, one, what is the role of rehabilitation and treatment? And two, what is the role of incarceration?
I am a little limited in this because I'm already a judge. I can't answer some questions. However, I do believe that rehabilitation is important, and I do strive to find a way to get to that answer at the end of the day. Sometimes it requires some creativity on my part or on part of the attorneys in front of me. I do try to give people as much as possible. Segue to get to what they can do. But again, I really can't answer a lot of specific questions without violating my judicial canons. And I'm not trying to be difficult. I am trying to give you the best possible answer within my confines as a judicial officer.
Okay, thank you. And Ms. Rebecca, 1 minute.
So my theory of punishment is that a civilized society uses punishment in a way to improve the functioning of society, not simply because it's how things have been done in the past or to placate any particular party. And what we've learned is that most people committing crimes are not doing so because they think the punishment is tolerable. They're committing it because of poverty, because of mental health, or because of substance abuse issues. Well, some people do commit crimes because they think that they won't be punished or because they think that they will just get away with it. I think that the issue is generally not that they don't think that the punishment is insufficiently severe. So I think the majority of criminal cases actually can be resolved with rehabilitation and treatment. Jail and prison have their place and probably will always have a place in the US criminal justice system. And sometimes prison or jail needs to be the stick when the carrot is the rehabilitative measures that we're trying to get people to pursue. But I think that in most cases, prisons and jails also need to implement their own treatment plans to mitigate mental health issues to the best of their ability, because most people will still be released eventually and they will not be better off after having served that term.
Thank you. Okay, the next question, we will start with Rebecca this time. Ms. Rebecca, so 1 minute. What do you think can be done to make criminal justice system work more fairly and effectively in Los Angeles County? That's part one of the question. The second part is, what do you think Los Angeles courts could do better in their handling of civil cases?
So I think that to the extent that outcomes are unfair in, say, criminal cases, it's because there's a lot of inconsistency in prosecutions. People are not treated the same in, say, San Fernando versus downtown or airport court or Long Beach. And well, as judges, we don't have a lot of control over what the prosecution offers. Obviously, we can have more uniformity in sentencing in terms of the factors that we consider. I do have more limited experience with civil cases, but I would say that based on what I hear from litigants in civil courts, most of the issue is that they don't know how to navigate those court systems that they are in, and that they're often in against their will. So if they're denied a job because of an illegal background check, they don't know how to avail themselves of that system. I think the expansion of legal clinics that are often in the courthouses and help people to navigate those systems both results in more just outcomes as well as actually making the work more efficient, because you don't have people that, for instance, don't know that they need to file proof of service. They have that guidance.
Thank you. Okay, Ms. Spear?
I would echo my opponent in that the access to justice is extraordinarily limited, and it's devastating. Especially, I worked in family law as a judge for about 5 years. I'm sorry, are you guys hearing me? My apologies.
Yes.
Okay, it's showing me a warning. Anyway, I would echo her in many of those things that access to justice is a very difficult issue. Although I will say that I think it's a case by case analysis. I think that people tend to think that of these things as this is what we should have as a rule, and you cannot do that. We need to work on each individual, what they need to be successful, and we need to take each case individually. We can't make a rule saying all persons are great or all persons are bad. We need to talk to them and see what they need to be successful going forward in the future. So that's my analysis when I am sitting in court and listening to these cases, either in family or in criminal.
You're muted, Fatima.
Ooh, I should know better after COVID times. My apologies. How do we balance issues of free speech rights with the need to enforce hate crime laws? And we will start with Ms. Spear.
I think I would probably reiterate what I just said, which is to say that you have to evaluate each single person's case independently. And it's difficult because I think people want a rule that says this is what we're going to do, but that's not always a good rule. So I think the balance for me would be listening to the case, figuring out what is in actuality going on, and making a decision based on what the actual facts of the case are.
Thank you. And Ms. Rebecca.
Yeah, so because this is in the context of criminal cases, I think it's interesting because I don't know that there is a need to control just offensive activity. As a general rule, with the exception of criminal threats or challenging someone to a fight, it's hard for words alone to be a crime. And I don't think that in the context of criminal law, for that reason, there's actually that much balancing to do. Someone yelling something terribly offensive, even if it's sexist, racist, or homophobic, or any form of slur, it's not a crime, or if it is, it's a more minor one that is content neutral, like disturbing the peace. So someone yelling something offensive as they commit an assaultive act, that's something different. That suggests that they are doing that assaultive act because of the person's race or gender identity or sexual orientation, and that is not a free speech issue. If you're committing a crime and that crime may be subject to a sentencing enhancement, it's not because of your words, but because of what our words tell us about your intent. And your intent is a proper subject for the criminal court to consider.
Thank you. The next question, it's a two-parter. If you become aware of unethical conduct on the part of a trial advocate in a case in which you're presiding, how would you handle it? Do you believe judges should be required to report attorney misconduct? And we will start with Ms. Rebecca.
So like most of these questions, I think this is going to be very fact-based. The question itself does assume that I know the conduct is unethical and it's not, for instance, an honest mistake. And I do think we should be careful about accusing officers of the court on either side of misconduct when ignorance or mistake is an adequate explanation. But depending on the degree of misconduct and the impact it has on a trial or proceeding, I would, at minimum, admonish the advocate. And if there is a jury, admonish the jury to not consider any misconception created by it. If the misconduct was severe enough to warrant a mistrial, I would grant that mistrial. If it was a misconduct that was committed by a prosecutor and it warranted a mistrial, I would consider dismissing the case with prejudice because that is what that would require if it was truly unethical conduct. And if I'm required to do so, I would also report that attorney to the state bar. I do think judges should be required to report attorney misconduct if it is unethical in nature. Zealous advocacy by either side does sometimes skirt the line of what is permitted, but when one side crosses a clearly delineated line, something that's established by a prior court order, then there should be a consequence.
Thank you. Ms. Spear.
This has in fact happened to me a few times, and it's a difficult situation because you have to balance whether or not they are advocating for their client and whether or not what they're doing is part of their advocacy or if it's just outside of the bounds of their advocacy. And so when it has happened to me, I have had to skirt that issue. And so usually I will just admonish first. counsel, you are out of line. Possibly you need to take 5 minutes and figure out what's going on with you. When they are beyond that, then yes, I do report it up. There is some difficulty in it. As a judge, you cannot just directly make an admonish or an appeal to the attorney board. You can, but there's some difficulty with respect to what rules we can cover. And so it has a little bit more levels of intricacy than what my opponent has just described. It's not as easy as just making a phone call. For me, if I were to make an admonishment to the legal board, I would have to tell them that this is what happened and this is why, and I'd have to have grounds for it. So it's a little bit more complicated than what she's describing. Thank you. I'm sorry. I did see your sign.
Right.
Okay.
The next, it is challenging to do this in 1 minute. So, we understand. And they're very important questions. So the last question is, if you've served as a judge before, tell us about a case you presided over that you think exemplifies your judicial philosophy and why. If you haven't served as a judge before, summarize what your judicial philosophy would be. And we will start with Ms. Spear.
Hold on, am I back? Okay. I went through quite a few family cases because I was in family for about 5 years. And the ones that stick out to me the most are the ones involving children, because trying to figure out where a child should go at night, who they should be with, which parent is the best parent for them, how I can make their lives better, that is what sticks out to me the most. I did have one case that was very, very difficult. I remember doing interviews with the kids, and they were very, very upset. The long story short is that there was some involvement of sex crimes, but this was in the family context. But I was able to interview them because of my history of working in sex crimes and crimes against children. I was able to talk to them, talk to the children, figure out what was going on, and find the best placement for them. And so that is, I think, one of the most exemplary cases without using their names or anything else that I can't say.
Thank you. Ms. Rebecca?
My judicial philosophy would be one that begins with restraint, and I think that that is a thing that is often overlooked by judges. They begin with the thought of how can I help the situation, which is a good instinct, but it sometimes misses the point that many people's lives are not actually improved by court involvement. And the key question of does the matter in front of me require court jurisdiction has to actually be answered at some point. Now, once it's determined that the matter does warrant court jurisdiction, my judicial philosophy is ensuring that everyone is heard and that they have an understanding of why the ruling was what it was. I think it's important to have clear rulings. It seems like sometimes judges are trying to avoid making a record because they think it'll be easier to get reversed on appeal if they do. But I think it's more important to ensure that the parties know why a ruling was what it was and feel that they were heard. And that's part of doing the right thing, even when it's hard. And of course, that involves also speaking to children if it's children that are parties in the case. And I did that as well when I represented children directly in children's court, including sex abuse.
Thank you. Now we will start with closing statements. You will have 1 minute. We will start with Emily Spear. Whenever you're ready.
Thank you. Just getting myself unmuted. As I said earlier, I am committed to women and children. I have spent more than a decade prosecuting those crimes. I'm sorry that I can't give you specifics because most of them are difficult to talk about, but that is my passion, and that is what I've advocated for my entire career, and that is what I will continue to advocate for. That is a very important thing. Not only that, but also getting them access to court and having them understand that there are ways to get the court's help, which might just be simple things like trying to figure out how to do your paperwork so you can get a divorce, or so you can figure out how to do your restraining order. those are such difficult things for people. Even as a judge, I would have a difficult time going through all of that. And so my passion is that I will hope to continue to advocate for women and children in my capacity as a judge.
Thank you. Kimberly Rebecca, your closing statement.
Thank you. I've been an advocate for the last 11 years, and some of the things I'm most proud of as an advocate are getting a client an exemption for his initial license denial so that he could work at a group home, so that he would know that his life wasn't over because he got a felony 10 years ago. And the kids in that group home also knew that their life wouldn't be over if they made a mistake like that. And I obtained unemployment benefits for a man who was fired from Superior Grocers so that he could feed his family while he looked for a new job. I advocated for children to not get reunification services with their dad who had sexually abused them. And I was the only person in the room doing it. I also convinced a prosecutor to dismiss a domestic violence case against my client because I had good evidence that she was the actual victim in the case. And I found a drug treatment program for a man who is deaf and hard of hearing. And it's the only program in the US, and it's in San Diego, when the prosecutor wanted to send him to prison for 2 years. But every time I had to convince a prosecutor or a judge to do the right thing. And as a judge, I wouldn't be an advocate, but I would be able to just do the right thing. And I hope I have that opportunity. Thank you.
Thank you. And thank you both for running for office. It's not an easy thing to do. So thank you for your service. I will now turn this back over to Margot Reed for closing remarks.
And the League of Women Voters does thank you both for making yourself available to participate in this candidate forum so that our voters in LA County have a better opportunity to learn something more about you and how you perceive your role. This video will be posted on YouTube, and the link to it will be posted on the LA County League website, which is www.lwvlacounty.org. The League of Women Voters also provides a free website for all candidates for county and other offices on the March primary ballot. It is called Vote 411. And our candidates have started to participate in this very helpful League voter information website. So look for their profiles of these candidates for judge, for candidates for district attorney, and all the other offices that appear on your ballot at Vote 411. You may make your plan to vote by entering your address and accessing your specific ballot and then reviewing all the candidates who are on your ballot. You can even save your choices and print them out and take them with you, or use them to mark your vote by mail ballot, which you should have received by this time. Thank you again for participating, and we wish you well in this election.
Thank you. Thank you for having us.
Good night.